Thank you so much, Josh Nathan, for joining us today. Josh Nathan is a partner at Clean Tech Law Partners and is here to tell us a bit about legal aspects that you guys should all know as early stage startups or early stage small businesses. So I'm going to go ahead and just hand it off.
All right. Thank you, Sydney. Hold on. Can people see my screen still?
Now it's showing your Zoom tile. There we go.
This meeting is being recorded. Got it. Okay, cool. All right. Well, thank you for the introduction. My name is Josh Nathan. As mentioned, I'm an attorney with a law firm called Clean Tech Law Partners. Clean Tech Law Partners is an international law firm dealing exclusively in renewable energy, clean technology issues. I've been with the firm for about 8 or 9 years now. I'm based in Chicago, Illinois, but the firm has presence throughout the world: North America, South America, Asia, Middle East, so forth. So thanks everybody for joining. The two general topics that I'd like to discuss, given the audience of people who are individuals who are starting up companies. So the first topic that I want to cover is choosing the type of business formation that makes the most sense for your purposes, and there are a couple. Probably 3 options or so that we'll discuss in various amounts of depth. And the second portion of the presentation, that once you establish your company and you start actually transacting business, you're going to be entering into various contracts. So I thought it would be beneficial to cover basic contract terms that you should be aware of that could, benefit or be to your detriment depending on how those particular clauses are negotiated. So I have a handful of slides that I'd like to get through, and then after I get through the slides, I'll open it up for questions and I'll entertain any questions that you have. I will start out by saying that talking about business formation and contract terms they're not the sexiest topics in the world. It's not all that easy to make them, entertaining, but I'll at least try and keep them interesting. And hope you bear with me through, some dry topics, but hopefully they'll be of interest given, your station in your business and company development. So the first topic is discussing different business formation options. The first thing, I think the most important thing to consider, or two of the most important things to consider when you're deciding what formation your company is going to take is, one, what's the best way to shield your personal liability? And the other is to maximize your potential tax benefit or tax exposure. So the 3 types of entities that I want to talk about are corporation, limited liability company, and not-for-profit companies. I'm not going to talk at length about partnerships or sole proprietorships because there's not a tremendous amount of legal significance to those types of entities because there's no formation documents, there's no filing, and you just hang out a shingle and you're exposed potentially to personal liability. So from a legal standpoint, I would not recommend running a business as a sole proprietor or a partnership, because you will be exposed to personal liability. And one of the beauties of these three options here is that if established correctly and run correctly, you will be, with a few exceptions, insulated from personal liability. So I want to talk first about limited liability companies and corporations, because those are the two most likely options that you're going to entertain. I'll talk a little bit later about nonprofit corporations, but unless you're a church or a synagogue or a mosque or an educational entity, it's unlikely that you're going to qualify to be a nonprofit entity. But we will touch on it a little bit later, just to give you the flavor. So the two main options are limited liability company and corporation. Both limited liability company and corporations have the advantage of protecting the individuals from personal liability. That's why these types of entities were established. So people like you and me can form companies without exposing our personal assets or personal liability. The first, and I think the most common for startup companies, the most common entity is a limited liability company, where you, depending on what state you're in and or where you want the formation to be, but a limited liability company is an entity that is formed that, again, protects the individual from personal liability. It, as far as tax ramifications go, most limited liability companies, they're called disregarded entities, which means that the entity itself is not taxed, but the taxes are passed through to the individual members who are members of the entity. And one of the advantages, the reason why limited liability companies are so prolific and common these days, is it's easy to establish, it's easy to maintain. There's not you can form a limited liability company in 15 minutes in the state of Delaware, literally, and probably other states as well. But for certain business reasons, filing reasons, tax reasons, a lot of companies elect to form their limited liability company as a Delaware company, even if they don't work or live in Delaware, and they're not even going to be transacting business in Delaware. But it's just a common state to do it in, because it's less expensive and there are less formalities and hoops that you have to jump through to establish the company. So if you look on the right column under maintenance, it says there are no formal annual requirements, no shareholder meetings or officers, no board of directors. On a later slide, we'll talk about an operating agreement, which you will enter into most likely if you do establish a limited liability company, just so there's some meat on the bone, so there's some form of progression and operating. But the key takeaways for limited liability companies are pass-through taxes, relatively minimal ongoing maintenance, and shielding from personal liability. If you look at the far left here under entity type in this red, where it says, oops, sorry about that, limited liability company are not recommended if you're looking to raise money through investors, or if you're looking to eventually go public. There are no public limited liability companies, and most investors would prefer to invest in corporations and not limited liability companies for tax purposes. So the other main option, other than limited liability company, is a formal corporation. Difference between the common theme for a corporation with respect to compared to limited liability company is you have, again, the benefit of shielding the individuals from personal liability. But a couple main differences in a corporation is corporations are taxed separately as corporate entities, and the shareholders are also taxed as individuals. So there is a double taxation element to corporations that you don't have with LLCs. And another, moving to the right now on the maintenance side, corporations, especially if you're going to be a stock corporation with shareholders, there are more bells and whistles that you have to adhere to that you wouldn't otherwise have to if you were an LLC. And that is, you have to have a board of directors, shareholder meetings, stock certificates. There's just a lot more paperwork involved with establishing a corporation compared to a limited liability company. But again, the advantages to opting for a corporation or over a limited liability company is if you plan on either going public or you plan on raising money through investors. The third entity type, which really it's a little bit of a misnomer, that the S corporation. An S corporation is a corporation. However, if the corporation is small enough, it has less than 100 shareholders and only has one class of shares, you can elect with the IRS to be an S corporation, which gives you the option of having the benefits of the limited liability company, where you could have the pass-through, excuse me, you could have the pass-through tax option as opposed to the double taxation in a regular C corporation. So, so as you anticipate forming your company as a startup, again, unless you're going to be a nonprofit, which we'll talk about a little bit later, your two main options are a limited liability company. And if you have any questions, please jot them down or keep them in mind. And then after we get through the slides, I'll be very happy to answer whatever questions you have. So that's the basic explanation or differences of the LLC and the corporation. Just get a little bit more granular on the tax advantages. As a disregarded entity, LLCs have pass-through taxes. No, the entity itself is not taxed. And it gives you a greater flexibility because you can eventually choose to have the entity tax as you grow. And if you do want to move from being an LLC to a corporation, that's a relatively easy maneuver to make if your business grows, and it makes more sense to get into the corporate realm as opposed to the LLC. S corporations, as we talked about on the first slide, is a corporation that's smaller, only has one class of taxes, that has the pass-through option on the taxes. The regular C corporation is more advantageous if you want to raise money, and if you plan to keep a lot of the money in the entity itself, as opposed to dispersing it to the individuals. because corporations are typically taxed at a lower rate than individuals. Another advantage to corporations is there are certain retirement plans, stock options, employee purchase plan, share purchase plans that are only available in C corporations and not available on the LLC. Now, once you establish either the LLC or the corporation, you're most likely going to want to draft a separate document which governs the operation of the company. If you establish a corporation, you're going to have a set of bylaws. If you establish an LLC, it's called an operating agreement, but they cover very similar territory, where you're going to identify, if you're a corporation, you're going to identify a board of directors, you're going to identify certain officers, president, vice president, secretary, treasurer, and so forth. In an operating agreement, it won't be quite as formal for the LLC as opposed to the corporation, but you're still are going to want to have an operating agreement that specifies which members have which roles and who's going to govern the entity and who's going to be making decisions. Most states don't require you to have an operating agreement if you're an LLC, but I'm going to recommend that if you go the LLC route, you do opt to have an operating agreement, because if and when you're ever audited, hopefully you won't be, but if you are, it's much more likely that the state is going to protect your insulation from personal liability if you have a operating agreement as opposed to not having an operating agreement, because an LLC without an operating agreement can potentially, not automatically, but can potentially be viewed as a partnership, and then you won't get the tax advantages and you won't get the advantages of being protected from limited liability. So in the guts of the bylaws and our operating agreement, you're going to have board of directors if it's a corporation. You're going to have members if it's an LLC. It's going to address percentage of ownership rights, who has voting rights, and how many votes does each shareholder or member have. Powers and duties, distributing profits and losses, and what happens when someone wants to exit the company, or if the company is sunsetted, how you divvy up the profits and the responsibilities. All these things are much better to hash out in advance before issues come up. And one very strong point that I want to make about the operating agreement and the bylaws is a lot of startups are put together by members of the company that know each other very well. They're friends, they're relatives, they've been in business before. And at the outset, everybody's on the same page, everybody has the same vision for the company. And, it's all very, warm and fuzzy. But I can tell you from personal experience as a lawyer and as personal experience, just as being in the business world for the last, 30 or 40 years, that regardless of how good a relationship you think you have with your fellow stockholders or fellow members, when push comes to shove, if things don't go exactly as planned, it's really much, much better to have a detailed operating agreement to agree upfront what happens in certain circumstances. What happens if someone leaves? What happens if someone dies? What happens if someone wants to sell a portion of their shares, but not all of their shares? All these mechanisms it's to your advantage to have them, to have all these issues discussed and agreed to on paper before things, potentially go south. And you maintain friendships that way, and you maintain the family relationships that way as well. So I want to talk very briefly about nonprofits for two reasons. One is 95% of the companies that I deal with are corporations or LLCs. I just don't deal with nonprofits as nearly as much as the others. And it's just much less likely that you're going to choose to go the nonprofit route, again, unless you're a religious or educational institution. And to become a nonprofit, you have to apply with the IRS to get tax exempt 501c3 status. There's a form to be filled out, and there's a tremendous amount, because you're not paying taxes, there's a tremendous amount of filing and upkeep with the state agencies and the federal agencies to make sure that you're maintaining your exempt status as an education, religious, or research entity. So if any of you are seriously thinking, if you fall into one of these categories of education or religious support, and you want to talk more specifically and more deeply about establishing a 501c3 tax exempt entity, I'll give you my information. Please feel free to contact me at any time. But since it's just much more likely that the majority of the people on the call are going to be forming LLCs or corporations, we're gonna focus on that.
Josh,
yeah.
We actually have a question in the chat very much related to this particular case. And yeah, we have quite a few nonprofits in our cohort, and probably this question would be relevant to them as well. Do you want me to read it, or can you read it?
I think I see it. We have an existing nonprofit which runs nonprofit thrift store at the primary source or as the primary source of funds or charitable work. We're exploring the idea of manufacturing entity to create products using textile waste from the thrift store. So we're thinking of essentially adding a manufacturing arm under our existing nonprofit. Are there major risks with that approach? By contrast to, say, establishing a new entity or separate nonprofit that would have special access or gotcha. Okay. Okay, good. So you are it's an existing 501c3 that you want to add a function to an existing entity. So my best answer for that is you would not need to establish a separate entity as long as your waste system functionality is part and parcel with the existing 501c3 company, and as long as you're not putting in danger your qualification as a 501c3 entity. You certainly can. I mean, the optionality certainly exists for you to establish a separate entity for the waste stream system. But if you're an existing non-for-profit entity, there's no legal reason why you wouldn't be able to add the waste stream functionality to the existing 501c3, as long as you're not violating any of the state or federal 501c3 tax laws. So I don't see any risks, any major risks with the approach of adding that waste stream functionality to an existing 501c3. Does that answer the question?
Yes, thank you. So I'm Tiffany. This came from me. I think that does help us. Yes, I think we're a bit concerned that in the early stages, it's going to hurt our statistics in the sense that as this business gets off its feet, the share of our spending that's on charitable work versus basically the cost of administration or the cost of creating these services is going to be higher in proportion to what it is right now by comparison to our charitable work. But of course, as the business or as this manufacturing part of it develops, those numbers should be back under control.
Right. Right. Yeah. Always when you either start a new entity or you add some functionality to an existing entity, there's always going to be, an early, upfront, cash outlay and, a learning curve to make the entity work seamlessly and not violate your status as a 501c3. But I think, since you've already established a 501c3, I think it makes sense without, adding a tremendous amount of risk to, add this waste stream functionality to it because you've already established the existence and the the qualifications of the 501c3. So I think you're ahead of the curve there. It's just that you just make sure that as you move forward with the waste stream, functionality, that you're not doing anything, overtly to jeopardize the existing 501c3 and the nonprofit status. But I've seen this done, before. I've seen existing 501c3 entities add whether it's a waste stream or a solar array or any other sort of clean energy functions to an existing company. It's done all the time. I don't see a tremendous amount of risk, again, as long as you're not violating, you're not contradicting your current qualification as a 501c3. Okay to move on?
Thank you, Josh. Thank you.
Yeah. Okay, pleasure. All right. So if anybody else has any questions on the 501c3 LLCs or corporations, please ask when we get through with the slides. But I like to shift gears a little bit now, because once you establish your company, regardless of what entity format you choose, whether it's LLC, corporation, or non-for-profit, once you start operating, you're going to be entering into contracts. And I thought it would be helpful just to take a couple minutes to go through common clauses in contracts that could cause issues or raise your liability, or at least the potential of liability. So there are a handful of clauses that appear in just about every contract that you should be aware of when you're entering a contract or negotiating a contract. And I listed these 5 categories of contracts. Obviously, there's a lot more, but these are the most common ones, at least in my experience: equipment supply, services, warranty, operations, and maintenance. And the clauses that I want to talk about specifically apply to all 5 of these contracts and really apply probably to just about any contract that you're going to contemplate entering into. So in no particular order, the first category of clauses is with respect to payment terms. Now, depending on what side of the transaction you're on, you can be the buyer, you can be the seller, you can be the contractor, you can be the owner. That is going to frame how you go about negotiating, these particular terms. But payment terms, the first and most basic term that you're going to want to address is when you get paid or when you're obligated to pay, depending on which side of the transaction you're on. And it's typical to have terms that say that payment is due within 30 days of receipt of invoice or 60 days of receipt of invoice. Obviously, if you're the purchaser, you're going to want to negotiate as long a period of time as possible to pay once you get the invoice. But the 30 to 60 day time frame from the time that an invoice is issued is pretty typical. I've seen 15, I've seen 90, but 30 to 60 is pretty much the norm. You're going to also want to be very clear as to what is included in the invoice. The time frame that it covers, the services that it covers, the specific equipment. If it's an equipment purchase, you're going to want to be as specific as you can, especially as your business grows, as to what information you're going to require on an invoice before you agree to pay it. I put down currency because in my world, just about every contract deals with at least one entity, at least with two entities from different parts of the world. And if you're dealing with, like, for example, I'm working on a big project now in Mexico. It's a US company, but they're building a factory in Mexico. So there's a tremendous amount of negotiation as to, are they going to pay in pesos? Are they going to pay in dollars? How does the exchange rate work? Obviously, if you're only dealing with US based companies, then that's not an issue. But the more global the industry becomes, the more likely you're going to be dealing with foreign or international companies, and the currency is going to be a very important element to the agreement. Also, the mechanism of getting paid is very important: wire or electronic funds transfer. If you're the provider of the services or the equipment, the safest way to get paid is through wire or EFT. And I would recommend, building that into your contracts. It's the most efficient way, and it's a very easy way to track getting paid as well. Warranties, pretty standard. You're going to want to, again, depending which side of the transaction you're on, if you're the purchaser, you're going to want as long a period of time of warranty as possible. If you're the provider, obviously the shorter time, but typically speaking, for equipment, for equipment supply, warranty terms is anywhere from 1 to 2 years from the date that the equipment is delivered to the purchaser's facility. The clock starts ticking, and you have 12 months from that point in time to file a warranty claim if there's a defect. Services is a little bit more, there's a little bit more fluctuation in terms of the warranty time frame for services, because it's just harder to quantify and to identify defects. So for services, I've seen time frames anywhere from 30 days to 12 months and everything in between. I identified implied warranties, and the implied warranties issue applies to the equipment sales much more than services sales. And it works like this: if I purchase a widget, and the owner and the seller says, okay, this widget will work properly for 12 months, and it will function for those 12 months, and it will accomplish XYZ for the specifications that are attached to the equipment. An implied warranty would be, okay, I just purchased a piece of equipment from you, seller, but I expected it to perform above and beyond what the specification said or what your proposal said. That's what's called an implied warranty, something that the party expects the equipment to perform, but was not explicitly written in the contract. So again, depending on what side of the transaction you're on, if you're the seller, you are going to want to explicitly exclude implied warranties, because you don't know exactly what the purchaser's expectations are. So what you're going to want to say to protect yourself is, I'm selling you this piece of equipment. The specifications of this piece of equipment are an exhibit to the contract. And my warranty to you is that this piece of equipment will work as warranted per the specifications. And if you have expectations above and beyond that, that's not my responsibility. The last bullet point on the warranties I wanted to discuss briefly is delivery and liquidated damages. Because depending on how important that piece of equipment is to your business, you may negotiate a term in the contract that says, I'm purchasing a widget and I need it delivered by May 1st, 2023. And if I don't get it delivered by May 1st, 2023, my business is going to suffer because I can't, my factory's not going to be at full capacity without that piece of equipment. So if you don't deliver, supplier, by May 1st, I'm going to charge you X dollars a day or X dollars a week for each day or week that you don't deliver beyond the date that you told me that you would deliver. And this is a very common clause in energy contracts, in clean tech contracts, in any sort of construction or manufacturing, because without the equipment, obviously you can't run the business as you'd like. So it's very common for purchasers to say, if you don't deliver from the time that you say you're going to, and we're very careful not to call it a penalty, because courts don't like the word penalty when you're looking to enforce a contract. So what we say is something to the effect of, if you don't deliver by such and such a date, it's understood that I'm going to be damaged by X dollars per day. And this is not a penalty. This is a real anticipated number that I'm going to lose if you don't deliver on time. So again, depending on what side of the transaction you're on, you're going to want to negotiate. If, as the buyer, you're going to want to negotiate up as high a liquidated damages rate as you can, and if you're the seller, you're going to want to keep that low. But it's a really important clause, especially today when we're dealing with equipment shortages and service shortages. It's much more likely today than it was 15, 20 years ago for deliveries to be delayed. All right, this next slide, force majeure. 5 years ago, I may not have even had this slide up here, but because of COVID, force majeure and excusable delay has become probably the most important and heavily negotiated clause in supply and service agreements. Your typical, so let me back up, because maybe not everybody understands what force majeure means. Force majeure means that if I'm a supplier and I have agreed to supply or perform certain services by a certain date, there may be some things out of my control that prevent me from doing it. Acts of God, severe weather, strikes, change in law. There may be a lot of things that happen outside of my control, and I don't want to be penalized for not delivering or performing on time because something happened out of my control. Now, before COVID, these types of clauses weren't negotiated all that heavily because acts of God and war and strikes, don't happen every day. But because of COVID, now all of a sudden this has become front and center. And when I'm negotiating a contract on behalf of a client, especially on the supply side, I want a very robust force majeure clause that specifically addresses COVID and says that if I can't perform because there was a stay-at-home order or a shutdown because of COVID, I don't want to have to be held liable for not performance because that's out of my control. Here's the flip side. The flip side is a buyer is going to say, well, wait a second, COVID's been around since 2020. You already know it exists. It's not something that's unpredictable or unforeseeable. We're living in it right now. So I'm not going to give you relief for a COVID-related delay because you already know about it. So when that happens, the compromise typically is as follows. Okay, as of today, April 8th, April 6th, 2023, I, as the supplier, I guarantee you that I will deliver by a certain date, and I won't be allowed to claim COVID-related delays as an excuse unless something changed between today and the day that I was supposed to deliver. If there's a new strain, if there's a shutdown that happens post execution of the agreement, I want to be able to claim that as a force majeure event. But I'm bringing it up because count on it being a very heavily negotiated term, much more than it's ever been before. And on this last bullet, there are two types of relief that a supplier is going to be looking for if there's an event that causes them to be late. And the typical relief is schedule. I told you I'd deliver it by May 1st, but I was delayed for 6 days outside of my control. So from May 1st to May 7th, I don't have any liability or responsibility for being late. That's the typical remedy for force majeure. Price relief is a little bit more difficult to sell as a supplier, and typically a supplier only gets a price adjustment if there's a force majeure if the cause of the delay was the counterparty. If the buyer caused the delay, they weren't available to receive the equipment, or they didn't give you access to their factory to perform the services, then in that circumstance, sellers are entitled to a price adjustment in the contract if they can prove that because of the buyer's inability to accept the goods, that they incurred a financial loss. But those types of remedies are very heavily negotiated, and again, because more now because of COVID and source and raw materials availability is a much bigger issue than it ever was before. Termination clauses, which apply, I think, more to services agreements than supply agreements, because you supply what the goods that you're contracted for, and then you're done, except for potential warranty issues. But in a services agreement, if I'm providing maintenance services or operation services on your plant for multiple years, termination clauses do come into play. The typical termination clause is for cause. If one of the parties breaches the agreement, the buyer doesn't pay on time, or the service provider isn't providing the services that they promised, then you can terminate the agreement if there's a breach. The for convenience element, it's interesting because I come across this all the time in construction agreements where the buyer may say something may happen between now and 2 years from now when the facility that I'm purchasing to be designed or built, I may change my mind midstream, and I want to have the opportunity to terminate the agreement even if the counterparty isn't in breach. That's why it's called for convenience. And in that situation, if I'm representing the seller, I don't want to give the buyer the right to terminate for convenience. But if they insist, then we typically have a clause that says something to the effect of, you buyer, you can terminate this agreement even if I, seller, supplier, I'm not in default, but you have to A, pay me for all the services that I performed up till the termination, and you have to pay me for any out-of-pocket expenses that I incur as a direct result. I might have already paid my sub-suppliers or my subcontractors to supply your project, and I'm going to have to pay them a termination fee because I'm terminating their contract without them being in default. So you have to, if you're going to go the termination for convenience route, it's really important to have a very explicit set of terms for what the party who's not terminating is entitled to. All right. I think this particular, with the exception of the force majeure, this is probably from a legal standpoint, the most important part of the contract, the limitation of liability and consequential damages. And here's why. If I contract with you to provide you a widget for $5, but the widget is defective, and because that $5 widget didn't do what it was supposed to do, you have to shut down your factory, you have to shut down your machinery, whatever it is, and as a result, you're losing money. So not only do you have a faulty $5 widget, but you're not able to conduct your business until it's fixed, and you're losing tens of thousands of dollars, if not more, while you're not able to run your business because of the defect. So what typically happens is the buyer's going to say, I want you, seller, I want you to take responsibility for any losses that I incur as a result of your defective widget. The seller's going to say, wait a second, I'm only getting $5 for this widget. I can't afford to take $100,000 worth of liability if my widget doesn't work properly. So what typically happens, and this is all negotiable, what typically happens is the parties agree on a limitation of liability where they'll say, okay, I'm selling you a $5 widget, but if something goes wrong, I'll agree to compensate you up until a cap of X dollars, $100, $10,000, $1 million, whatever it is. But most sellers cannot afford to enter into a contract that doesn't have a cap on their liability, because their margins on their services and the materials that they're supplying, only allows them, to make X amount of dollars. And it's just not good business sense to accept $1 million worth of liability for a project that you're only making, a $20,000 profit on. So that's why it's really an important element of the contract to negotiate a reasonable cap based on the circumstances and based on the value of the contract. Now, if the seller is grossly negligent, is fraudulent, commits intentional misconduct, goes into is installing the widget in your equipment, and he's drunk, or sets fire to your facility, or something just completely out of the ordinary, just grossly negligent or acted intentionally, then these caps don't apply. Then all bets are off. You cannot exempt yourself from liability if you're acting grossly negligently or fraudulently. And then the last major clause that I want to talk about is choice of law and venue. When you enter into a contract, the contract's going to say, well, in the event something goes wrong, the parties agree that the laws of this state will govern the terms of the contract, and that you have to bring litigation in court in the state that the contract identifies. Now, the parties will want to negotiate to have any disputes resolved in their state where they live or where they're conducting business. And the other party is going to want to do the same. So if you can't agree on which state's law is going to govern or where you're going to have to bring the lawsuit, it's common to agree on New York law or Delaware law, because they're just, they're well-known contract laws that's fair to both sides. And, it's common to agree on a neutral site or choice of law. The last bullet, and this is the last thing that I want to talk about when it comes to contracts before we open up the questions, is the litigation versus arbitration discussion. Now, the common thought is that arbitration is advantageous to going to regular, circuit court, because the view is that arbitration takes, quicker, the process is faster, and that it's less expensive than going to court, which could take, years and legal fees and so forth. And that's partially true. When you work with, and I've had cases with the American Arbitration Association, and arbitrations, depending on the complexity, can take years, and you can end up spending a tremendous amount of money on legal fees in arbitration. But I will grant the proponents of arbitration that on average, it probably is less expensive. But here's the downside. The downside to arbitration as opposed to litigation is an arbitrator is not obligated to be bound by the exact terms of the contract or of the prevailing law. A judge in a court is. An arbitrator, what arbitrators typically do, not all the time, but what arbitrators typically do is they tend to split the baby. They tend to see, both sides, and they try to come up with a judgment that, isn't all one side, winners and losers. I don't like that, because I'm negotiating this contract for a reason. I'm negotiating this contract to protect my client. And if I'm going to go to an arbitrator, an arbitrator is going to say, I don't care what the contract says. I'm going to impose, a judgment that I believe is fair to both sides, regardless of what the contract says. Then that defeats the purpose of having, in part, of negotiating the contract. And I'll give you one real life example of what I'm talking about, and then we'll open it up to questions. I was representing, this is like 20 years ago, but I was representing a manufacturing company, and they put out a bid to subcontractors to bid on a job to perform construction services in Oregon. And so they got 5 or 6 responses, and they decided to go with, the cheapest option. the entity that proposed the smallest fee. They did their due diligence. They said, okay, this is a reputable company, but they're charging less than the other guys, so I'm going to go with the lower fees. Well, lo and behold, the project didn't go so well, and the subcontractor said, you know what, I miscalculated. And when I bid on the project, instead of bidding, $10,000, I should have bid $50,000 because I made a mistake in my calculation. Now, if you go to court, a judge will say, I'm sorry, you made a mistake and you have to pay for it. In the arbitration, the arbitrator said, yeah, I get it, you made a mistake, but I don't want one side to be punished so much, even though they made the mistake, even though they miscalculated. So the arbitrator said, I'm going to, split the damages 50-50. And even though one side was much more at fault than the other, I'm going to impose a decision or a judgment that, makes it 50-50. And, as an attorney who negotiates a contract, I take pride, and most attorneys do, we take pride in negotiating the contracts to protect our clients, to put them in the best position in case there is some sort of contentious situation or default, and the arbitrator can just ignore it or water it down significantly. So those 5 categories of contract clauses, they appear in just about every contract: construction, maintenance, warranty, equipment supply, procurement, all those issues, force majeure, limitation liability. Those are things that you're going to need to be aware of in pretty much in every single contract that you negotiate, because you're going to want to protect your investment. You're going to want to protect your company from unreasonable liability, and don't expect things to go wrong, but definitely anticipate that things may go wrong. So that's what I got on the presentation portion. If anybody has any questions, either on the corporate governance or the contract, I'll be happy to entertain. Hold on, I think I see something in the.
Hey, Joshua. Yeah, I asked a question on the chat. So I'd be curious to hear your thoughts. So I have an outdoor gear rental website, and what I do is I connect renters and lenders. So I facilitate the rental amongst the two parties, and I collect payment, and then I pay out the lender at the end of the rental. I'm wondering if you have any thoughts on how I could best set things up to limit the liability for both the lender and myself in the course of a rental. And a specific example that I'm concerned with is, a situation like, let's say I facilitate a rental where a renter is renting a pair of skis. They go to, the local resort and they crash and tear their ACL, right? They might sue both the business and the lender in such a situation. And I'd be interested to hear your thoughts on what might be the best approach to limit the liability there in such a situation. I do have baked into the contract that it's a transaction between the renter and the lender, but that doesn't mean that the, renter can't still sue both parties. And, I would like to be able to protect the lender as would make sense, in the transaction.
Yeah, great question. And yes, and I agree with you that in your example, if someone rents the skis and tears their ACL, yeah, I guarantee they're going to sue everybody in sight and let you guys duke it out. And that's one of for better or for worse, that's how our litigation system works, where the aggrieved party is going to, name, as many parties as they can and let those guys, duke it out. So what I would recommend, but let me ask you this: how do you get your fee? Do you get your fee from the lender?
So I charge a service fee to the renter and to the lender. So the renter pays a surcharge on their order, which I take, and then before I pay the lender, I deduct a service fee as well. Got it.
Okay. Well, the best way, I believe, to protect yourself is in your agreement. It actually should be in both, with both parties, with the lender and the renter, but for sure with the lender, because in your example of the skis, if defective skis caused the injury, you don't want to take responsibility because it's not your equipment. You're just the guy in the middle. So what I would recommend is that you have language in your agreement with the lender, and it's called an indemnification clause, and it'll say something to the effect of, if I'm as the middle person, if I'm sued from a renter who rented one of your skis because they got injured because of your defective skis, you lender, you agree to indemnify, defend, and hold me harmless, because I can't take responsibility for someone who's going to get injured because of your faulty equipment. So you would have a clause in your agreement with the lender that says that the lender agrees to indemnify you as if you are sued by a renter of the lender's equipment. Does that make sense?
Yeah, makes sense. I'd be curious if there's anything I can put in place to protect the lender as well. I understand the indemnification, hey, I'm just facilitating, but I would, if possible, like to be able to protect the lender as well. Obviously, if they're grossly negligent in giving a pair of faulty skis that are clearly faulty, that's one thing. But, someone who is skiing for the first time, for example, tears their ACL and is just pissed off and trying to get someone else to pay for their medical bills. I'd like to ideally, provide some form of protection. Do you think there's anything?
Yeah, there's a mechanism for that. So I definitely go the indemnification route with the lender.
Yeah.
To protect the lender from a renter suing just because they were, clumsy and hurt themselves. I would put a clause in the contract for the renter that says something to the effect of, the renter understands that, that skiing is a potentially, dangerous activity, and that the renter is waiving any claims against the lender as a result of injury from the skiing, unless the lender is, as you said, is grossly negligent. If the renter could say, hey, your skis broke while I was going downhill and I broke my leg as a result, that should be on the lender. But the renter should also acknowledge that people get hurt skiing just by the nature of the sport itself, even if there's no defect. So there should be language that says the renter waives any claims against the lender unless the renter can prove that the lender was, grossly negligent.
Great. Okay. Thanks so much. This is very helpful. Thank you.
Yeah, you're welcome. Any other questions?
Yeah, hey Josh, my name's Alec, and I'm kind of early in the business development process, but I have a couple questions just related to what we're talking about today. So I started out as a sole proprietorship because it's obviously much easier. My question about LLCs is basically what are the real world cost implications. So I see there's like a $180 filing fee. you mentioned that the taxes can be similar to a sole proprietorship. Does that mean really that there really is no like tax differences in terms of like real costs to a business? So I'll start with those, and then I do have another.
Okay. So from a tax standpoint, the difference between being a sole proprietor and being a single member LLC, which is I think what you're describing, the differences are minimal, are minuscule, because whether you're a sole proprietor or a single member LLC, you're going to be responsible for the taxes of the income of the entity, and it's there's not going to be a major difference between an LLC and a sole proprietorship. Where I see the major advantage to you establishing a single member LLC as opposed to a sole proprietor is, I'm not sure what your business is, but it doesn't really matter. If as a sole proprietor, if something goes wrong, if you get sued by a customer of yours, your personal assets are in play. If you're a single member LLC, your personal assets are not in play. It's a function of how solvent the LLC itself is. But if you have $50,000 in the LLC bank account and someone sues you for $100,000, you're only at most responsible for the $50,000, even if they win the case, even if they can show that you were negligent, you breached the contract, whatever. They cannot reach into your personal assets and your personal bank accounts. So the advantage of proprietorship as opposed to a single member LLC is in the liability, not in the taxes.
Okay, that definitely clarifies some stuff for me. So that does mean that I would have to have a contract if I have an LLC. So who would be a good person? Who's writing my contracts, and like what kind of costs can I expect to be associated with that?
When you say contract, you mean the transactional contract between you and your customers, or do you mean the LLC agreement itself?
Well, I guess maybe
well, if you're if you're talking about a single member LLC, if you're talking about establishing an LLC where you're the sole member, then you wouldn't need an operating agreement. It wouldn't even make sense. So to establish the LLC, the filing fee, is $150, maybe $200, and you have to file an annual report with let's just say you're establishing your LLC in Delaware. Then it'll cost you $150 just to establish the LLC. It'll probably cost you $50 a year to maintain the LLC, just to keep the business afloat. And you wouldn't even need an attorney for that. Now, if you're talking about a transactional document between you and your customers, yes, that I would recommend getting an attorney. But if your business is where all you need a contract template, you need an attorney to draft an agreement that you can use over and over again for all your clients. You don't need to hire an attorney every time you enter an agreement. You just have the template and you fill in the blanks, the dollar amount, the name of the customer, the schedule, whatever. But to come up with a template agreement that you can use over and over again, that should not take more than a couple hours of time of a competent attorney.
Great, thank you.
You're welcome.
Tiffany, do you want to raise your question and read it?
Sure, thanks, Xenia. So I'm just trying to use this chance while we have you to think of these nightmare situations. For what we're proposing to do, which is again this textile waste and newly made products that are associated with our thrift shop, is there a need to have a sort of a blanket policy or some statement to our customers that we're not to be held liable for goods once they leave our shop? Just for context, this nonprofit thrift store has been around since the 70s, and we haven't had an issue. So hopefully it wouldn't be a problem. But for example, if someone like this nightmare situation, that we had a client in here who said that she had a cockroach infestation in another town, another state where she had purchased secondhand bedding. And so she was saying that now she always treats things when she gets home. So if something were to happen like that and a client tried to come say that we were responsible because of the reclaimed textiles we were using, is like we don't have a contract when someone purchases our goods. It's very simple. Is there something that we should do, either a contract like that upon each sale or a blanket policy pertaining to our entire shop or entire nonprofit? Thanks.
Yeah. Good question. Ideally, in a perfect world, you'd have a contract that absolves you of liability, but sometimes it's just, it's not practical. You can't enter into an agreement, a contract with every customer that walks into a thrift store. So I think there are two ways to potentially handle that. One is that when someone purchases something from you, you could have just some boilerplate language on the receipt that says that the purchaser is purchasing, the item or items as is, and is taking full responsibility once they leave the store. That will help. There's no such thing, I'm sorry to say, there's no such thing as protecting yourself from any liability for any circumstance whatsoever. That there's no such animal. But all you can do is protect yourself within reason. So if you put some boilerplate language on your receipts that says that once you purchase this item, purchaser, it's as is, and you waive any claims against the proprietor. That will protect you against most instances. The only circumstance I believe that it would not protect you is if you sold this may be a ridiculous example, but just to make the point, if you sell explosives, you sell fireworks, and you say, okay, you purchaser waive any claims against me, the proprietor, regardless of what happens. That the waiver may not apply there because you're dealing with something that's inherently dangerous. And if you're in the business of selling something inherently dangerous, a court will probably say you can't ask your customers to waive any liability against you under any circumstances because you chose to go into the business of selling dangerous equipment. So probably the waiver would not necessarily protect you. But 90% of the time, unless you're selling explosives, or guns or whatever, having a blanket waiver would protect you against 99% of the claims. And you could also put a sign up in the store that says, all purchases are final, all purchases are as is, and the proprietor takes no responsibility for any damages that incur after the purchase. Again, that will help, but it doesn't protect you 100% of the time, but under the circumstances, it's probably the best that you can do. For example, you know, and I'll give you an example of you know, of these waivers and why they're not, you know, perfect. You work, you know, I used to work in-house, you know, for big corporations, and they'd have you know, outings. They'd have golf outings or bowling outings or you know, sailboat, you know, sail whatever, and they would ask their employees to sign a waiver that says anything that happens to you while you're on this company sponsored item, you waive any claim against the company in case, you know, in case you get injured. Now that will protect the company in the sense that if someone gets injured and there was no overt negligence or gross negligence on behalf of the company, the you know, the employee can't have a cash grab just because they got injured because they were clumsy. But it does not, just because an employee or a customer signs a waiver that says I waive any and all claims against the employer or the company, that is not enforceable against overt negligence or gross negligence. But it is the best you can do under the circumstances. Does that help?
Yeah, that's really helpful. Just one more super practical question then. As a
Sure.
waste reduction measure, we do not always print a receipt. We ask people if they want that receipt. Many of them say no, but I think you maybe answered that. If we put a sign up in the shop that has that same sort of boilerplate language, that would also serve as...
It would mitigate your damages. It would not eliminate your damages.
Okay, thank you.
You're welcome. Well, any other questions?
Probably it's unrelated to any particular question, but as an organization and as a program, we are supporting for-profit and non-profit startups who are trying to develop their ideas in circular economy. And in many cases, some of the businesses, they are looking into collaborations with nonprofits who have that access to tax-exempt practices and maybe grants. Is there a way for them to collaborate in a legal way?
Is there a link to collaborate with someone to help them raise funds?
Like, for example, there would be a business who would get some sort of material from a nonprofit and donate some of their revenues to nonprofit back. So this kind of collaboration.
Yeah, it's similar to the previous question. Yes, you could always build into your relationships, safeguards that protect you from liability and minimize the risk. And you can absolutely put language in your partners or potential partners or people that are going to be investing or contributing. You can absolutely, and I can offline, please feel free to contact me. I can give you language that would accomplish that, and I would recommend that you do that. But again, it only goes, the protection only goes so far. That the general rule of law is that you can protect yourself from liability. You can put in all the safeguards that you want in your agreements and your relationships, and you should. But most courts do not allow you to waive or exempt yourselves from liability if you're either the negligent party or you cause some damage. So the easy answer to your question is yes, there are ways to protect yourselves. There are ways to mitigate the damage. I'd be disingenuous if I said that there are ways to completely insulate you and and absolve you of all responsibility, and, make it clear that you under no circumstances can be, can be liable. To answer your question directly, yes, you can mitigate your exposure in that circumstance, but you cannot eliminate the risk. But, please feel free to contact me directly and we can talk about specific language.
Thank you. And it looks like we don't really have any particular questions.
Okay. So I just want to, there we go. So this is that's me. That's my email address and my phone number. And if anybody, and I'll be sending a copy of these slides. So you'll have the slides. But to the extent that you think of other questions that come up that you didn't think of, during the presentation, please feel free to either email me or call me directly, and I'll be very happy to, to talk in greater detail about any questions that you might have. Happy to do that.
All right. Well, thank you so much for joining us today and giving everybody so much awesome information. I guess everybody, just a quick round of applause. That was so helpful, so knowledgeable. Thank you so much. Before everyone else goes, let me just drop that link again for the feedback form. So I put it before, but I will drop it again. And I lost the link. One moment.
I'll do it quickly.
Oh, you got it fast? Cool.
Mm-hmm. Thank you so much, Josh.
My pleasure. My pleasure. Happy to participate. It's a great program, and wish you guys all the luck in the world in your startups. And again, please don't hesitate to reach out.
Thanks, Josh.
My pleasure. Bye-bye.